We also know Fani Willis, in addition to losing her case badly, being exposed with her lover stealing money from Georgia, is now ignoring congressional subpoenas. Is she going to indict herself for refusing to follow the law? So she plans to defy the subpoena. She did that today. Fulton County DA is not showing up. She got a pair of subpoenas and she skipped the hearing. Her attorney said she's not showing up. Move is now going to set up a showdown in court where her attorneys have argued that the subpoenas are void because they were improperly issued and they were overbroad. She got a summons. She was supposed to show up there today in front of the Georgia Senate, and she did not. And here is exactly what that sounded like when Fani Willis was flouting the law.
The last person on our agenda, of course, is the first person, Honorable Fani Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
No, she wasn't there.
Chairman.
Yeah. Thank you. Then let's please note for the record that Ms. Willis has failed to appear in compliance with the subpoena and has failed to produce the documents requested by our subpoena for the production of documents.
Flouting a congressional subpoena from Congress in her local state. Now, here's a little bit more. We'll listen to a little bit of this from the hearing. This is what it sounded like when it got started.
This morning, I will call to order Senate Special Investigative Committee. We have a full agenda this morning. First, we need to approve our minutes from the last minute, and then we have subpoenaed Fani Willis to testify.
Here?
According to press reports, she is defying her subpoena and not appearing, but we will welcome her if she appears at some point during the meeting. We also will have a presentation by Mr. Stuart Morelli of Legislative Counsel's office. If you look in your folder, you will note that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative investigation, administering oaths to witnesses and issuing subpoenas. So we are guided by their work and their legal advice. So I wanted Mr. Morelli to educate the committee and the public on this process of an investigative committee, as well as our subpoena powers. Following that, Mr.
All right, let's fast forward.
20 case would not have been in the 2016.
No, sir. And I'm going to provide some information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in 2020. In the Mazars case, the Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each house has the power to secure needed information in order to legislate. And they cited to a 1927 opinion of theirs, McGrain v. Dougherty. The Mazars case, the Mazar court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1927.
So they've got the power to subpoena Big Fanny, is what he's saying.
And went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently.
Where are you at, Fanny?
As I said, in 2020, the Supreme Court was citing back to its 1927 precedent, upholding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigations going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissenting view that I'm aware of was stated by Justice Thomas in the Mazars case. He did believe that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided.
No Fanny.
No other justices joined in that opinion. Other state Supreme Courts have continued subsequent to the issuance of Mazars to continue to also uphold state legislative investigative powers of their legislature.
Was that an 8-1 decision then? Or?
Justice Alito dissented.
All right, so she should be there. Let's see if we get some other questions.
Okay. And as far as you're concerned, does that constitutional provision also apply to investigative authorities as set forth by Senate Resolution make sure I remember the number here. We have this in the folders as well, 465.
I see no reason why that provision would not apply to a standing or a special committee as well.
Fanny should be there. There's
It
more.
was my hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial.
Okay, so even more. So they're laying a ton of foundation here, a lot, that saying Fanny should be there. Okay, we got all this precedent. Supreme Court has said it. Georgia has said it. Let's continue to fast forward and see what else we got.
That courts, when considering legislative subpoenas, in certain cases, in Mazar's case, the president, need to show some heightened concerns to recognize the separation of powers. I've been a bad attorney and not giving you the cites.
You got a whole bunch of attorneys on here, and you got a couple of non-attorneys that are as smart as.
And I can provide copies of any and all of these cases to any members who wish them. The citation for Dean versus Bolton is 235 Georgia 544. And again, it was a 1975 case.
Where's Fanny?
Of course.
Yes, sir.
Okay. So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations. That
Is this whole hearing going to be about why
inherent.
Fanny is violating a subpoena? I love it.
28, which were subsequently added, much more, I think in, the early 2020s, the detailed ethics provisions that give a second independent statutory procedure.
This is now a hearing about how
for the
subpoenas
ethics
work in
committees to
Georgia.
issue
I love it.
subpoenas.
The whole hearing.
All right. Other questions? I would, Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA
Thank you, sir.
55, 15, 17, and 19. When were they adopted into law and by which governor was it signed?
I don't know which governor. They were initially enacted into law I do have that before me if you will give me a second.
Okay, we have another guy who's going to come testify. So let's see who this guy is.
And tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there. My name is David Cook. I am the former Secretary of the Senate. I received my law degree from the University of Georgia in 1982 and have been associated with the Senate actually going back to 1977. And the Dean case that you were talking about earlier, I remember very well. It was my first year as the reading clerk for the Georgia Senate when Roscoe Dean was tried on my birthday, January 27, 1977.
Happy birthday. Let's see what else we've got. All right, so I think it's a hearing about
and
subpoenas.
distinct in each house and may be exercised through a committee. That's Mason 7795-11. So the creation of the committee, I think, was done in accordance with statute, in
Wow.
accordance with rules, but it was also done in accordance with our precedents. And Stuart touched on.
Okay, this is hilarious. So Fanny didn't show up, so their other witnesses are just people to say, these guys are just testifying about, one, how valid the subpoena is, and number two, how valid the committee is. So I love it. It's just like they're rubbing her nose in it. And they're doing it like total gentlemen. They're just hanging out, just chatting.
What the Senate's powers are, not as restrictive of it.
So they're
So those are my
pre-butting Fanny's objections. They're
prepared
just doing it
comments
in
today.
public. She's saying this is
I'm happy to
overbroad.
try
This
to
committee is
answer any
illegitimate. You have no
questions that
subpoena
you might
power.
have
The whole hearing
on this.
is just about
Happy to.
how they do have
hear
the
from
power.
Counsel on anything that I might have said from a legal perspective.
All right, let's see how it wraps up.
Under the attorney-client privilege, our rules do permit, I think it's Rule 5 of our committee rules, that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation stands, now would be the appropriate time to move.
Hold her in contempt.
For that. I recognize
for not being
Senator
there.
Kennedy.
Thank you, Mr. Chairman, for that. And I would move that we do pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, at that time, then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena.
All right.
Thank you. We're adjourned.
All right. So that's the hearing. So interesting. It was an interesting one, actually. It was a very, what's the right adjective for it? But in Fani's face. Okay, here you go. Oh, you don't want to show up and be here? We'll just talk about how wrong you are for a full couple hours with some very qualified people to do that. So Fani's having a bad day, thrown in the middle of litigation, people asking questions why she's allowed to ignore subpoenas and flout the law, flout legal process in Georgia, while she then prosecutes everybody else, while her daughter is driving around on a suspended license multiple times. She shows up in t-shirts on a Saturday with Nathan Wade, probably after a night of indictments and Grey Goose. And now she's just, I don't know, probably on a cruise somewhere, maybe watching the thing on her phone. So we'll see what the Georgia Senate does with this. Hopefully we have some contempt proceedings escalating here very soon.